I'm interested in Rick's suggestion about this off-the-rack idea, but I'd like to think back. In the 1970s, Milton Friedman did a series of television programs about the free market idea. And in all of these, he appeared in a farmer's market and talked about the idea of the farmer's market as if it's a free market as if it's the farmer's market. And we all know, of course, that the modern economic system is not like a farmer's market, unless, of course, you're at a farmer's market, but even the grain market isn't really like a farmer's market. But your idea, and I suggest that it might be time to rethink this kind of quaint notion of the marketplace of ideas that is based in some 19th century idea of how the marketplace of ideas may or may not have worked back then. And so there's this premise that we can't regulate that marketplace of ideas, but we do in fact have antitrust laws, as poorly as they may be enforced. So why not an idea, particularly in the space of, say, television advertising, where one candidate with enough money can buy all the advertising time well in advance of an election and therefore suppress the speech of the less well-financed candidate. So that is not more speech, it's less speech. And so you may want to think about it in terms of diverse speech rather than more speech or less speech. And your more speech inherently in that context, a zero-sum context, and it's, you could say, well, you can buy space on the internet, but it's not the same. So how do you deal with that problem, that the marketplace of ideas that is so fundamental to the First Amendment idea really doesn't exist in the same way anymore?
So that's a great question. First of all, I think the analogy to the free market in the economic context has really no relevance because there's not a First Amendment right or constitutional right in that context. So I'm not sure it carries any weight. I have colleagues who think it is the same, but it's not. And they would just say that we've screwed up the free market, that's all. And having screwed it up there, we sure as hell don't want to screw it up in the political arena. So their perspective in this would be simple. I think you're both right and wrong. I do think that constitutional law, in all respects, has to be capable of evolution, and there are certain circumstances where we may most often underprotect rights, and we figure that out over time. There are circumstances where conditions change, and that leads us to recognize that certain things are unconstitutional that weren't in the past. It's much less common when we go the other way. It's historically been kind of a one-way ratchet, that over time we see things as more likely to be unconstitutional and constitutional. On the other hand, with the Commerce Clause, for example, we've done the opposite, right? There we basically allowed government greater authority. So I think it can be a two-way ratchet, and I think that if the case can be made at a certain level, that we trust government to regulate this marketplace sufficiently that we can do one of two things. We can either amend the Constitution, which requires a lot of work and effort and is dangerous, but that's the simple way of doing it, simple quote. And the other way of doing it is having justices, rewrite the First Amendment. I shouldn't put it that way. Rewrite First Amendment doctrine so as to produce a better doctrine. And we do that all the time in constitutional law, and I think it's sometimes wise and works well. Other times, as in Citizens United, it's a disaster. It really depends in that context how much you trust the justice. But my guess is people in this room wouldn't want the justices on the Supreme Court today to feel that they had free rein to revise the First Amendment general principles in a fundamental sense. But in principle, there's nothing wrong with that suggestion. For me, I would have to be extremely convinced that government regulation of the marketplace of ideas is necessary to preserve democracy. And I don't think we're anywhere remotely near that conclusion. I'm going to have to run. I'm sorry. I have to catch a plane.
Go ahead.
Sorry. This will give you a chance to catch up.
I was just going to say something. I actually was going to respond to that comment, but since Jeff is leaving, I'll say that one thing that Jeff has had the same views on the First Amendment for a long time. He's been very powerful advocate for that perspective. But I only want to say one brief thing in response to that question, and it maybe helps sharpen up this discussion. There are very expansive kinds of arguments that you hear people making to justify campaign finance regulation, like the marketplace of ideas critique. And I think that those are all very troubling arguments. Money isn't speech. Corporations have no right to speak at all. The marketplace of ideas critique. And what I'm trying to develop here is what I think of as actually the narrowest kind of argument and the one most likely to be persuasive for things like campaign finance regulation, which is not a general critique of the marketplace of ideas, and it's not an argument that corporations have no First Amendment rights, and it's not an argument that the marketplace of ideas is all distorted. It's a very, very specific argument about elections. It's tied to the distinct role elections play and the distinct ways in which their role can be compromised or undermined. And I think that both strategically and kind of intellectually, I mean, I agree with this, this is the most effective way, if any forms of argument are going to be effective for getting at campaign finance regulation. And actually, it's very important to resist these extremely sweeping arguments that have much, much more profound ramifications for long-established First Amendment understandings. And that's why I'm so interested in developing this particular electoral exceptionalism idea.
I did want to recognize Bert, who I know has a question, and we can keep going.
I suggest an attack on Jeff.
Yes, exactly. I'm sure there's some sort of Latin proverb that you're not supposed to attack the absent, but
I wanted to. Is this on? Yeah. I wanted to say that the debate should make it clear to all of you why it's such a joy to work with both Jeff and Rick, and even with Sam on these issues. And I knew that if the two of you talked long enough, you'd converge, and I think you do converge, and you converge in an interesting way. Jeff wants to know, he wants to keep the old pristine, show me what the compelling interest is, show me what the traditional First Amendment. What you've done is you've given, I think, a vocabulary for saying that we always test whether the government has a compelling interest by looking at the institution within which the speech is being used. So if it's a prison or a military or a school, it's not that we say the free speech rules don't apply there. It's just that because of that institutional context, there is indeed a compelling interest in regulating the speech, because otherwise the institution fails. And it's such a small move for you to then say, look, the real problem here is that the court is not acknowledging the corrupting potential of independent expenditures. That they have already recognized the corrupting potential of contributions and done exactly what you say they should do, factored that into an institutionally sensitive way of dealing with First Amendment doctrine, and that their real mistake is to not recognize that you don't have to slap somebody on the back and give them directly to corrupt him. You can corrupt him by surrounding him with independent money and having him worry about whether he's going to get it next time. And that's just as corrupting. Why wouldn't that be, if you're looking for the narrowest way of going at that, why wouldn't that be an important avenue for us to pursue?
Well, I think as a description of all the institution-specific First Amendment doctrine that's already out there, the court is actually kind of schizophrenic about this issue in ways that I think are revealing. So I agree, sometimes they'll apply strict scrutiny and compelling justifications and find that they're met because they recognize the distinct purposes and functions of particular institutions, but many times they don't even get to that point of doctrinal inquiry because it's so obvious that it wouldn't make sense to apply the general First Amendment in light of the purposes of the institution, that they, for example, don't require a school teacher to show a compelling justification for saying in a math class we don't talk about, Right, that's right. And I think that there's also a lot at stake here in how this is conceptualized, because these tests like compelling justifications like obviously aren't self-applying. And the minute the standards are raised in that way, courts can move into this mode where they demand all kinds of empirical justification that would never be available. And so I agree with you, we could get to the same place through that structure. It's not always used already, and I think, I'm worried about going that route, but I agree it's a plausible way of getting to the same place. I think Jeff and I would disagree about how to apply that framework, even if we agreed that that's the framework we should use.
He kept saying he wasn't telling us how he believed those cases should be decided. The way to smoke them out is to apply the standard and ask him how those cases were decided.
But look, I will accept the criticism. I think the one point that I do think is right in what Jeff says is that one does have to think through a lot more fully what the range of potential regulations are and why some should or shouldn't be acceptable and why not. And I think that's a serious challenge. And inevitably it will draw on existing First Amendment understandings to some extent.
Can you pass the mic back to the lady behind you, Bert? And please speak. It doesn't seem like it's doing anything, but it's for the recording. So.
Right. No, that's a very powerful and important question here, for sure. So, elections aren't obviously bounded in the ways in which a school or a prison might be. I think inevitably there would be a certain kind of arbitrary line drawing that would be involved, which is essentially what Congress came to after struggling with this issue over a long period of time, so that activity close enough to an election, and we can debate how close raises the risk of corruption to what sort of level, but that something like a 30-day window or more specific ways of identifying the particular kinds of electioneering that might be at stake would be necessary, because you're creating a kind of structure that isn't bounded in the same way. And to be sure, it will be somewhat arbitrary in the sense that, elections and issues are all wrapped up together, and there's not some sharp line between public debate and getting candidates elected. But I think that you have to accept that the line will have to be kind of created, and that it will not be perfect, and you want it to be sort of, as carefully calibrated to the legitimate concerns as possible. Whether Congress successfully did that or not in McCain-Feingold, I'm not really sure I have a developed view about, but it would look something like what Congress did.
Well, I thought that Jeff Stone's most powerful bit of advocacy was his throwaway line when he said, can you imagine what the government regulation would be like if you had a Republican House, a Republican Senate, and a Republican White House? Now, that's, of course, a partisan approach, but we're dealing with a House that has just passed a budget that repeals our social legislation back to before the New Deal. And we have a Supreme Court that will basically bless almost anything that comes out of this Congress. That's very troublesome. Now, I can't concretely figure out what they would come up with by way of regulation, but it wouldn't be McCain-Feingold, which came out of a bipartisan effort with good faith and a lot of thought on both sides.
Take the debates over the Disclose Act in response to Citizens United. So you have opposition to disclosure, which for many decades was thought to be the bipartisan compromise. How could you possibly be against disclosure? The Supreme Court had, with the exception of Justice Thomas, consistently blessed every form of disclosure that the court had ever seen. But it's become a highly partisan issue because people are making bets on how disclosure of corporate spending will affect incentives to spend and what the partisan consequences of that will be. So, it's a good example of how the failure of government to act can be just as partisan and self-serving, as I was saying, as government acting. In some ways, what the Republican members of Congress prefer right now is what the court says the First Amendment requires. I mean, that's largely the highly deregulated, laissez-faire, libertarian system, no disclosure, free spending. So obviously it's a tremendous worry, and I've spent a lot of time worrying about this in my academic work. And sorting out the kinds of regulations. Regulation is going to be inevitable, and non-regulation can be just as partisan. So, figuring out how to sort through the way doctrine ought to be applied to deal with that problem in the sphere of regulation of electoral politics is a hugely serious, difficult problem. But it arises in lots and lots of areas, and I don't think you can escape it by saying a very libertarian First Amendment is kind of a neutral answer to that question, and that takes care of all our worries about incumbent self-entrenchment and partisan manipulation of the system, because who could be using that for self-serving and self-interested reasons?
And Richard Briffault's essay in this volume actually kind of deals with that question, which is to say, if you're going to talk about a dejudicialized electoral system, then what are the danger signs that are appropriate to saying some of this regulation we are going to be more skeptical of than others, including incumbent reentrenchment. But I think his overall point is that using the First Amendment as a proxy for these danger signs really doesn't get at the essence of the problem. It's both under-inclusive and over-inclusive.
I think that brings us back to the book. And exactly. We'll teach you about signing books to make sure the bookstores can't return them after this is over. First of all, we want to thank in absentia Jeff Stone and Rick Pildes for the debate we've just heard, and it is a debate that rings throughout the pages of this terrific book. And it is a debate, we hope, that is not only interesting and is not only important, but will in fact eventually be reflected in not only the briefs before the courts, but in the doctrine of the Supreme Court. The goal here that we've all embarked on is nothing less than a new jurisprudential movement over many years to enable our democracy to perpetuate itself as a strong democracy, and to give those who are on the bench and those who are arguing in front of the justices the tools to allow that democratic self-government to exist and to flower. The ideas we heard here, we hope we will be reading and hearing in future years in the law of the land. That's what brought us to Citizens United, and we hope that is what will steer us out of the land of Citizens United. Thank all of you who are a part of this, those of you who are here at the Brennan Center, who are our supporters, our interlocutors who disagree with us. And I want to say again, thank you to our friends and partners at the Century Foundation, and to those here at the Brennan Center who made this happen. First of all, as I mentioned, Monica and her colleagues managed to do this while litigating the McComish case. And I want to thank our colleagues from our communications department, Janine Plant-Churlin, who had so much to do with making this book, as well as this event and everything we do, a reality. Editing it and rewriting it on the fly is very much appreciated. And her colleagues, Eric Opsel, Andrew Goldston, and Kaz Redrick, who have, among other things, enabled us to turn this space into, take the flood of '09 and turn it into the farmers market of ideas of 11 and beyond. Anyway, we hope you all got copies of the book, and the conversation will continue, and we thank you.